Hi, this is Jeff Dickstein. I'm the Chief Compliance Officer with Pro Teck, and today we'll be going over Appraiser Independence. So today we're going to cover Appraiser Independence laws, regulations, and policies. We're going to cover how the Appraisal Independence laws are at both the state and federal level. We're also going to cover Appraisal Independence regulation and policy as it is covered by the agencies, the GSE'S, and FHA. So what needs to be pointed out is while each law and each regulation and policy varies, there is some common language within all laws and regulations regarding appraiser independence. Basically, it covers that it is unlawful for anyone to make any attempt for any reason to persuade an appraiser to change his or her opinion of value. Obviously, the laws are in place to protect the independence of the appraiser from any threats, bribes, retaliation. It also is protection to protect them against withholding payment or a promise of future appraisal business or withholding any future appraisal business. So you might ask yourself, what can you do if you do have a question or inquiry about the appraisal report under review or preparation? So it's important to note that there is an exception requirement within Dodd-Frank that states that this will not prohibit an appraisal management company, employee of an appraisal management company, or any other persons with an interest in a real estate transaction from asking any appraiser to undertake one or more of the following items. So the first bullet point is to consider additional or appropriate property information, including the consideration of additional comparables in consideration for that appraisal report. The second is provide further detail or explanation for the appraiser's value conclusions. Or the third is to correct any errors contained within that appraisal report. So on the federal law piece, as far as appraisal independence, that was passed as part of the Dodd-Frank Financial Reform Act. That was signed by the President on July 21st, 2010. So it is important to note that the appraisal independence piece is a small part of the 45 pages of Subtitle F covering appraisal activities, which is a small part of the 206 pages that cover the Mortgage Reform and Anti-Predatory Lending Act, and that is just a small piece of the entire 3,200 pages that covers the entire Dodd-Frank Financial Reform Act. All of these rules and studies have not been completed as of yet, so things will change in the future, and I will be updating you as well as those changes occur. Okay, so let's look at Subtitle F within the Dodd-Frank Financial Reform Act. So Subtitle F amends both TILA as well as FIRREA. TILA is the Truth in Lending Act, and FIRREA is the Financial Institution Reform, Recovery, and Enforcement Act. I've included a hyperlink here so you can read that at your leisure. The rules that cover the act are drafted by the board. Now, the board is made up of the Board of Governors of the Financial Reserve, Comptroller Currency, FDIC, the National Credit Union Administration Board, FHFA, and the new Bureau of Consumer Financial Protection. The interim final rules were released on October 18, 2010, went into effect April 1st, 2011. They are still in effect as an interim final rule, and it is unknown if and when a final rule will be drafted by the board. So Subtitle F, Section 129E of TILA is what was amended by the Dodd-Frank Financial Reform Act. So Section 129E not only covers the appraisal independence language that we discussed earlier, but it also covers prohibition of conflict of interest, mandatory reporting, the portability of appraisal reports, customary and reasonable fees. It did sunset the HVCC upon the interim final rule, and it spells out fines for violating Section 129E of TILA. So the first offense violation for any of these items is $10,000 per day per occurrence, as long as that violation continues. The subsequent violation bumps that $10,000 up to $20,000 per day per occurrence. So it's very important that we're all aware and follow all of these guidelines and highlights. It's important to note that we're acting as an agent on behalf of our clients. These appraisal independence laws are in effect for our clients as well as us as their agent performing AMC services. Interagency Appraisal and Evaluation Guidelines. This is separate from the Dodd-Frank Financial Reform Act. These are the guidelines that are drafted by the agencies that oversee lending institutions and credit unions and servicers. So these guidelines are drafted by the board for our clients to follow in reference to appraisal and evaluations that they may use within their institutions. It's important to realize that the agencies that make up the board audit their lenders, servicers to make sure that they are in compliance with these interagency appraisal and evaluation guidelines. There's also a section in the guidance that states how our clients must oversee their third-party relationships. So our clients get audited by their regulators to make sure they're in compliance, and our clients come here to Pro Teck and they audit us to make sure that we are in compliance with their guidelines in regards to appraisal and evaluations. As part of the Dodd-Frank Financial Reform Act, this sunset the Home Valuation Code of Conduct, or HVCC. HVCC went into effect May 1st, 2009, and was an agreement between the GSE'S, Fannie Mae and Freddie Mac, and the New York Attorney General Office. So it was only an agreement between those three parties. This was not policy, it was not regulation. But because Fannie Mae and Freddie Mac were the only people buying secondary loans, this became commonplace throughout the industry. So HVCC was the initial Appraisal Independence document that spelled out all of the prohibitions on appraiser independence. All of those guidance points carried over to the Appraisal Independence requirements when those were implemented by Fannie Mae and Freddie Mac in place of HVCC when it was sunset. So the Appraisal Independence requirements became policy with Fannie Mae and Freddie Mac a few days before the drafting of the interim final rule from the board or the agencies. So the appraisal independence requirements were taken from HVCC, and they are in place as part of policy in the seller service guides for the GSE'S. So anybody doing business with Fannie Mae, Freddie Mac has to comply with the appraisal independence requirements as stated in AIR. Department of Housing and Urban Development, or FHA, also has their own appraiser independence policies that is outlined in their Mortgagee Letter 2009-28. This has prohibition against mortgage brokers and commissioned staff from participating in the appraisal ordering process. It states the policy outline for appraiser selection within the FHA Connection website. And it also has outlines about appraisal and appraisal management company and third-party organization fees. It also references an earlier mortgagee letter 1996-26, which did have the same language as far as appraisal independence safeguards, criteria around appraiser engagement, knowledge of the market area, as well as addressing geographic competency for any FHA appraiser. So in addition to the federal laws, federal regulations, GSE and FHA policy, a number of states have their own appraisal independence laws built into their appraisal licensing statutes. I've included a link here to the Appraisal Institute's website, which they have a very comprehensive list of each state's breakdown and their language around appraisal independence, which is very similar to the same language at the federal level. Okay, so you might be asking yourself, we have state laws, we have federal laws, we have regulations, we have policies all around appraiser independence. Why so many? Obviously, we had a rather large mortgage meltdown a number of years ago, and a lot of that was tied directly to improper influence of appraisers and some inflated appraisal values for home mortgage. So this is an all-encompassing fix to all that. So Dodd-Frank covers the federal piece. The regulations cover the lending institutions as far as policies and regulations that they need to maintain appraiser independence. The policies as far as the GSE'S and FHA are if you're doing business with those agencies, you need to follow these policies, And then the states also have theirs because they are the ones that issue these licensing credentials for the appraisers. So they need to have that in their state piece as well. So it is important that not only everyone here at Pro Teck understand the complexity that appraisers have to comply with, but also the complexities that we have to comply with as far as knowing and understanding the federal laws, all of the regulator policy and regulations, as well as policies set forth by the GSE and the FHA, and understanding state laws on how we can interact with our clients and the appraisers in performing a valuation that is free of any type of influence to try to get the most accurate valuation we can. So what do we do here at Pro Teck to safeguard some of these appraisal independence requirements? When any appraiser uploads any appraisal valuation into our system for review and delivery to the client, they must check and certify that there was no appraiser independence violation in preparation of that appraisal report. The reason we do this is so that we do have this on record that the appraiser did certify that there was no violation of appraiser independence in performing the valuation if anyone ever questions that in the future. Pro Teck does have a dedicated appraiser independence hotline as well as a dedicated email address for anyone to report any improper influence of an appraiser. It is monitored all the time, and we encourage anyone to provide us with information where appraisal independence has been violated. I thank you very much for your time. If you have any questions regarding this, please do not hesitate to contact me. I look forward to talking with all of you. Have a good day, and thank you for your